let's see how much we can accomplish in the next half hour. Let's dive in. Contracts. Contracts will cover about 12% of your licensing exam. The elements of a valid contract in California are legally competent parties capable of contracting, mutual consent, also known as offer and acceptance, legal purpose, sufficient consideration. Legally competent parties are those who have the legal and mental capacity to enter into a contract. Contracts entered into with legally incompetent parties are voidable at the option of the incompetent party, but may be enforced against the competent party. Minors may enter into contracts, but the contract isn't enforceable by the other party to the contract.
So for example, you're an adult and you hire Chuck, the 14-year-old kid from across the street, to mow your lawn every week for $20. If Chuck forgets or gets busy or just never does it, you can't enforce this contract. It's voidable because they're an incompetent party. However, if Chuck mows your lawn and you don't pay him the $20, he can enforce the contract, even if verbal, against you. You're a competent party. You agreed to give him $20. So don't be cheap and pay Chuck. Let's say you hire him to watch your beloved dog, Muffin. If Chuck forgets, well, you can't enforce that contract against him. He's 14. However, again, if he watches Muffin and takes care of Muffin, you have to pay him because you're a competent party. You agreed to that. Make sense? Great.
California law prohibits minors under 18 from entering into any contract related to real estate. For example, a minor cannot buy or convey real property, and a real estate licensee can't represent a minor in a real estate purchase or sale. These limits do not apply to emancipated minors. Parties who may enter into a contract include emancipated minors, aliens, individual proprietors, partnerships, LLCs, corporations, nonprofit associations, personal representatives, and convicts. Mutual consent, also known as offer and acceptance, occurs when the parties enter into an agreement voluntarily with a full understanding of contract terms. The contract must be voluntary. Mistakes, misrepresentation, fraud, duress, or undue influence create a situation in which the consent is not real. A signature is the party's confirmation of understanding and intention regarding the terms of the contract, but a valid contract can be made without signatures, as in a verbal contract. However, signatures make the contract more easily enforced in court. Legal purpose means that the contract results in a legal outcome. A contract written for an illegal purpose is void. Consideration. Consideration is something of value given in exchange for another thing of value. For example, the buyer gives the seller money in exchange for the seller's transfer of marketable title to the buyer through delivery of a deed. Valuable consideration is usually something of economic value, though it can be an action or a promise to not act. Although not deemed valuable consideration, a gift is deemed good consideration and meets the required element of consideration in a valid contract. Earnest money in a real estate contract isn't consideration and isn't a required element for a valid contract. Contracts may be valid but unenforceable. For example, a voidable contract is valid but may not be enforceable in a court of law. Contracts signed under the following circumstances are unenforceable. The contract is for an illegal purpose. One or more of the contract parties were under duress or undue influence. One or more of the contract parties committed misrepresentation. The contract terms are patently unfair or violate public policy. The contract contains errors. The Statute of Frauds requires that certain types of contracts, such as for a property ownership transfer, be in writing to be legally enforceable and to prevent injury from fraudulent conduct. A contract that doesn't comply with the Statute of Frauds can still be valid, but it's unenforceable. The Statute of Frauds also requires written contracts to identify the contracting parties, identify the subject matter of the contract, present the essential terms and conditions of the contract. A voidable contract is one that appears valid but one or both parties have a legal right to disaffirm it. This could be because one of the parties lacks legal competence, or because there was a mistake or misrepresentation, causing a failure of reality in consent. The contract is voidable by the incompetent or misled party, but enforceable against the other party. A void contract isn't a contract at all, because it lacks one or more of the requirements for a valid contract. It also has no legal force or effect. It's unenforceable. In contractual language, performance means meeting the terms of the contract. The parties should operate in good faith to execute the contract with no deceptive practices. All parties must comply with contract terms in a timely manner. Time is of the essence. An executed contract is one in which all parties to a contract have met all contract terms. A contract for the sale of real estate is executed by the delivery and acceptance of the deed and the payment of the purchase price. Notice that you can also see the terms executed used to refer a document that's been signed. Contracts are executory until all of the promises in the contracts have been completed. A contract for the sale of real estate is executory until the deed is delivered and accepted. Breach of contract occurs when one party fails to meet contract obligations. The innocent party may take any one of several actions as a remedy to the breached contract. Partial performance is when one party meets some but not all of the terms of the contract. The innocent party may agree to accept partial performance, perhaps in return for some sort of compensation. The innocent party can sue for damages. This is a means of seeking monetary compensation to make up for any harm caused. A specific performance suit seeks to force a party to make good on the promises made in some way, usually by requiring the breaching party to perform the original contract terms. Many real estate contracts include a liquidated damages clause that limits buyer damages to a return of the earnest money if the seller breaches the contract. Contract discharge, aka performance or execution, means that the parties have met all contract terms and are discharged from their contractual obligations. When one party to a contract agrees in writing that the other party is no longer held to the provisions of the agreement, this is called release. Contract rescission, cancellation, generally results from an operation of law, such as breach of contract, destruction of the object of the contract, etc. If the contract is rescinded, it is terminated, and the parties are legally returned to their position before there was a contract. For example, if one party breaches the agreement, the other may legally have the right to rescind the agreement. This is known as unilateral rescission. Parties to the contract may terminate the contract through mutual agreement. This is best accomplished through mutual written release. Assignment means to transfer contractual rights or duties to a new party. Some contracts have provisions either permitting or prohibiting assignment. The phrase "and or assigns" after a party's name in the contract makes the contract assignable. Unless the parties agree that the original buyer or tenant is to be released from contract obligations, the original party remains liable if the new party fails to meet the contract's obligations. Novation occurs when one contract is substituted for another. The agreement may be between the same parties, or a new party may be substituted. This is novation of the parties. The intent between the parties is to discharge the old obligation, releasing the original party from those obligations. Insertions to pre-printed forms are interpreted in a specific order of priority. Typed insertions take priority over pre-printed material, and handwritten insertions take priority over typed and pre-printed material. Numbers written out alphabetically prevail over numerals. State laws govern the use of electronic documents and signatures. The Uniform Electronic Transactions Act UETA, UTA, is an attempt to bring some degree of standardization to state laws regarding the use of electronic documents and signatures. It gives electronic signatures, records, and contracts the same legal weight as paper records with wet signatures, signed by hand in ink. The UETA defines an electronic signature as an electronic sound, symbol, or process attached to or logically associated with a record and executed or adopted by a person with the intent to sign. Electronic documents and signatures can only be used if the parties to the contract agree. In a bilateral contract, both parties have obligations. Most real estate contracts are bilateral. For example, a purchase contract contains promises by both parties, so it's bilateral. In a unilateral contract, only one party makes a promise, like I promise to pick you up from the airport. An option contract is one example of a unilateral real estate contract. A contract clause is a section or provision within a contract that addresses a specific point of law or aspect of the agreement. Common contract clauses include choice of law, specifies that any dispute arising under the contract shall be determined in accordance with the law in a particular jurisdiction. Indemnification means one or both parties commit to compensate the other for any harm, liability, or loss arising out of the contract. Contingency clause defines a condition or action that a party must meet in order to not be in breach of contract. An arbitration clause requires the parties to resolve or attempt to resolve their disputes through an arbitration process. A mediation clause requires the parties to attempt mediation prior to engaging in arbitration or legal action. A statute of limitations clause in contracts states the time frame in which a party can file a lawsuit relative to the contract. The California statute of limitations for written contracts is 4 years. Unwritten contracts have a shorter statute of limitations of 2 years. When parties agree to other terms that are outside a main contract, these terms are included in an amendment or an addendum. All these documents together form the complete agreement between the parties. An addendum is an addition to an existing document, such as an offer to purchase. It adds terms not addressed in the main body of the contract's form. An amendment is a change to an existing contract between parties. It changes one or more of the original contract terms. For example, if the closing date must be changed, the parties can execute an amendment. The broker should recommend and/or approve addendum and amendment forms. Remember that addendum is an addition. Add. Amend, change. Listing agreements. Listing agreements are contracts between a licensee and a consumer who become agent and client to sell real property. There is no requirement that the listing agreement be on a specific form. However, to be legally binding, it must be written in clear and unambiguous language, and it must be signed by all parties to the agreement. Common practice is for agents to use pre-printed forms designed by the California Association of Realtors or their local multiple listings service. Licensees must avoid extensive changes or additions to the language on the standard form to avoid the unauthorized practice of law. An exclusive right to sell. An exclusive right to sell agreement is the most commonly used type of listing agreement. This agreement provides the most assurance that the listing agent will receive the agreed-upon commission if the property sells, no matter who procures the buyer. Exclusive agency. Exclusive agency agreements only pay commission to the listing agent if a real estate professional procures the buyer. If the seller procures the buyer, no listing commission is owed. An open listing is a non-exclusive listing. The seller can have open listing agreements in place with multiple licensees. Only the licensee who procures the buyer earns the commission. A net listing is an agreement in which the seller agrees to give the broker all net proceeds above a specified sales price. Net listings are permitted in California, but should be used sparingly, if at all. These listings pose an inherent conflict of interest that could occur if the listing agent fails to present offers that leave little for commission, even though the offers might meet the seller's needs.
And while we're here, if you could subscribe, that would be so awesome, and it doesn't cost you anything. So thank you for your support.
The pre-printed form for the exclusive right to sell listing agreement is the Car Residential Listing Agreement. Licensees must have written agreement with a seller to establish the right to a commission. The rate of compensation must not be on a pre-printed form. A provision notifying the seller that commission rate is negotiable and not set by law must be included prior to the clause setting compensation rate. Protection clause designates a time period after the listing agreement expires when the broker is entitled to compensation if a buyer whom the broker procured during the period covered by the agreement makes an offer. Managing brokers must review and initial listing agreements. Listing agreements must specify a termination date. If the clients want to change any terms of the listing agreement after signing, such as extending the listing period or the list price, the agent should use the CAR Modification of Terms form. It is important to have all sellers on the title sign the listing agreement so it is legally enforceable. The CAR Residential Listing Agreement specifies the parties to the agreement, the property for sale, inclusions and exclusions, listing price and terms, and the terms of broker compensation. When a seller wishes to opt out of using the MLS or exclude specific information from the internet, the seller needs to sign additional seller instruction to the broker forms. Using the MLS increases exposure of the property on the market and the potential for the seller to receive top dollar. Listing agents need to be sure their clients understand their options regarding photographs, internet advertising, and key safe lockboxes, and the pros and cons of each. The residential listing agreement clarifies broker and seller responsibilities and duties. The seller and the broker agree to exercise reasonable effort and cooperation in the sale of the property. In the event of a dispute, California law requires that sellers and brokers attempt mediation before taking legal action, regardless of whether the seller and broker agree to this in writing. Provisions of the CAR Residential Listing Agreement address signs, equal housing opportunity, attorney fees, management approval, successors and assigns, and dispute resolution. Buyer-broker agreements, aka buyer representation agreements, establish the agency relationship between a licensee and buyer.
Hey, and while we're here, if you could subscribe, that would be so awesome, and it doesn't cost you anything. So thank you for your support.
Information required on the buyer representation agreement includes the type of property the buyer is seeking, the type of agency relationship that will exist, and what the terms will be for broker compensation. CAR standard forms includes 3 types of buyer representation agreements. Exclusive buyer representation, BRE, which entitles the licensee to compensation when the buyer purchases a property and prohibits the buyer from establishing an agency relationship with another broker. Non-exclusive buyer representation, BRN, which gives the licensee the right to compensation in exchange for showing the buyer properties. It allows the buyer to work with another agent and to compensate only the agent who represents the buyer in the transaction. Non-exclusive, not-for-pay buyer representation, BRNN, which forms an agency relationship that either party can break at any time and doesn't require the buyer to compensate the agent. Since most buyer agents are compensated through a cooperating broker agreement, this allows the buyer to work with an agent without being obligated to pay if that doesn't happen. All 3 types of buyer representations include important advisories as pre-printed addenda to the buyer representation agreement. The agreement allows the buyer to agree to dual agency, which permits the agent to show properties listed with the agent's brokerage, or to agree to single agency only, in which case the agent may not show properties listed with the agent's brokerage. Offers, purchase contracts. Offers to purchase are most often presented on a purchase contract form. Once signed by both parties, the offer becomes a binding contract between the buyer and the seller. Other names for forms used to draft a written sales contract are offer to purchase, Sales agreement. Contract of purchase and sale. Purchase agreement. Earnest money agreement. Agreement of sale. The sales contract identifies the parties and establishes the transaction's terms and conditions. An agent should request a driver's license, a passport, or some other method of establishing the identity of the parties. Information often included in a sales contract includes the earnest money deposit amount, specific closing instructions, closing agent selection, deed type the seller will present, the proration method for rent, taxes, other closing costs, buyer possession timeline, home warranty transfer, if available, and seller warranty specifics, if offered. Licensees should not determine the amount of earnest money a buyer should give or that a seller should accept. They can discuss what ordinary practice is, but they should allow the parties to determine the amount. The process of the buyer and the seller entering into a contract of sale typically begins when a potential buyer makes a written offer to a seller. Although the form used to make the offer may be called a sales contract, it is not a contract. It's an offer that isn't a contract until the parties come to acceptance. The party extending the offer is the offeror. The party receiving the offer is the offeree. In the event the seller accepts the buyer's offer, there is a contract. In the event the seller does not accept the buyer's offer, the seller will typically extend a counteroffer to the buyer. When this happens, the seller becomes the offeror, and the buyer is the offeree. Acceptance occurs when all parties have signed a contract, while binding acceptance happens when the signed contract is delivered back to the offeror. Acceptance and binding acceptance must take place within the dates outlined in the contract. According to the standard language in the residential purchase agreement, the offer expires if it's not signed by the seller and returned to the buyer within 3 days. If dates aren't specified, they must occur within a reasonable time. Licensees should be careful to use only approved forms for additional terms. Drafting contract language may be considered practicing law without a license. Licensees may fill in the blanks on a sales contract form. It's always a good idea to recommend the client review the sales contract with an attorney before signing it. Contingencies are conditions that must be met before the agreement of sale is complete and enforceable. Contingencies usually include the actions necessary to remove the condition, a deadline for its removal, and the party responsible for taking the actions to remove the condition. All contingencies to the contract must be satisfied at the specific times and dates called for in the agreement. Failure to do so is a breach of the agreement. The original offer is no longer legally binding. A home sale contingency makes the sale contingent on the buyer selling an existing home or property. A home inspection contingency makes the sale contingent upon a satisfactory home inspection. A financing or mortgage contingency makes the sale contingent on the buyer obtaining financing. An appraisal contingency makes the sale contingent on the property appraising at or above the sales price. The buyer's inspection advisory should always be included, and the contingency for sale of buyer's property form should be used when buyers need to make their offer contingent on sale. The greater the number of contingencies on an offer, the less attractive it is to the seller. A buyer's agent should caution buyers to use contingencies to protect themselves, but not kill the deal with too many contingencies. If a buyer misses a contingency deadline, they may lose their earnest money. If the seller misses a contingency deadline, the buyer may have the right to terminate the contract. Contract termination based on the inability to meet a contingency or on the other party's failure to meet a deadline typically requires written notice to the other party. A seller who indicates in the purchase agreement that a tenant-occupied property will be vacant but who cannot deliver may be held in breach of contract. Counteroffers. If the counteroffer is signed, it becomes a contract. Counteroffers kill the original offer and should only be used to counter unacceptable terms. Counteroffers are active until they are either accepted, rejected, or withdrawn. Finalize any counteroffer terms before responding to other buyers' offers. An express contract may be oral or written and clearly states the terms of the agreement between the parties. An implied contract has not been expressly agreed upon, but relies on the parties' actions to determine the agreement. A promissory note should include the date, initial principal and interest rate, terms of repayment, loan period, late fees, prepayment penalties, if any, and default circumstances and actions if the borrower defaults. A prepayment penalty is a charge to the borrower for the early repayment of a loan. The security instrument makes the mortgagor responsible for certain duties, which include pay the debt and real estate taxes, maintain adequate insurance, keep the property in good repair. Standard clauses in a security instrument include a defeasance or reconveyance clause, late charge provisions, an acceleration clause, and the alienation clause, which is also known as a due on sale clause. The power of sale clause is standard in the deed of trust, but may also be included in a mortgage. Acceleration clause, a clause that makes the entire debt due immediately in the case of borrower default. Alienation clause, aka due on sale, allows the lender to make the entire loan due and payable immediately if the property is sold or otherwise transferred. The presence of this clause can affect the ability of a buyer to assume the loan. Power of sale clause allows the trustee or the mortgagee, in the case of a mortgage, to sell the property in order to recover losses from borrower default using a non-judicial foreclosure process. Late charge provisions are found on the promissory note rather than the security instrument. A deed of trust uses a reconveyance clause, which requires the trustee to convey the deed to the homeowner when the loan has been repaid in full. A mortgage uses a defeasance clause, which requires the lender to execute a satisfaction of mortgage when the loan has been repaid in full. Provisions that can be included in a finance instrument to address specific needs are lock-in, prepayment, non-recourse, exculpatory, subordination, cross-default, partial release. Subordination. A subordination clause allows the security instrument's lien position to be placed in a lower priority to a new loan using the same property as collateral. For example, a developer purchasing a vacant lot may need a construction loan as well as the loan for purchasing the land. The subordination clause in the security instrument makes it possible to obtain the construction loan. Purchase, lease, options. An option contract, or option, is an offer to purchase a specific piece of real estate without the obligation to buy it. In an option contract, the potential buyer, optionee, is usually required to pay an option fee to the seller, or optioner. The parties to the contract set any amount as the option fee. There's no max or minimum. An option contract is one example of a unilateral real estate contract. If the optionee decides to exercise the option, the optioner is required to perform the contract terms, and the contract then becomes a bilateral contract. If the optionee decides not to exercise the option and purchase the property, the optioner typically retains the option fee. Some option agreements are a lease with the option to buy. The lessees have an option to purchase the leased property, should they choose to exercise the option. A lease with option to buy consists of two different agreements between the parties. One is a lease, and the other is an option to purchase. The lessor, optioner, and lessee, optionee, agree to specific terms that will govern the sales contract in the event the optionee decides to exercise the right to purchase during the term of the option. The optioner is obligated to sell if the optionee decides to exercise the right to buy, but the optionee is not obligated to buy. The lease is a bilateral contract, and the option is an example of a unilateral contract. Advance fee. An advance fee is any upfront fee a licensee charges for certain services, such as advertising or processing a loan application. It is illegal to charge advance fees for loan modification services. Advance fee agreements are legal for other services, such as listing a high-priced estate, if the California Department of Real Estate approves the advance fee agreement. And that is contracts.
Please like and subscribe. Thank you so much.